If someone ever tells you that a piece of paper cannot steal 600 acres, they have never met the wrong HOA president. That thought crossed my mind the moment I opened the certified envelope waiting in my mailbox on an otherwise peaceful Monday morning. I expected another routine community notice, maybe a reminder about landscaping standards or road maintenance, but instead I found a formal demand signed by HOA President Linda Mercer. According to the letter, I had exactly 72 hours to surrender control of my 600-acre lake because the association had determined it was now considered common recreational property under newly recognized community authority. If I failed to comply, the HOA would assume management, restrict my access, and begin preparing the lake for public use by the neighboring luxury development. I actually laughed at first because the claim sounded too ridiculous to be real. My family had owned that lake for nearly 50 years. I had inherited it from my father, who had inherited it from my grandfather. Every fishing dock, every wooded shoreline, every acre of water had always belonged to us. I folded the letter, climbed into my truck, and drove straight to the lake expecting to prove to myself that someone at the HOA office had simply made an embarrassing mistake. Instead, I found 3 pickup trucks parked beside my private entrance, fresh survey stakes driven into the ground, and workers installing polished wooden signs that read, "Future Residents Private Lake Access." My own entrance gate was still locked, yet people wearing contractor badges walked around as if they already owned the place. One of them politely informed me that construction schedules could not be delayed because the resort opening had already been announced. Resort? I had never approved any resort. Curious and suddenly uneasy, I continued driving around the shoreline until I reached a large promotional billboard featuring elegant lakeside cottages and smiling families kayaking across water that was unmistakably mine. Across the top were the words, "Experience exclusive HOA waterfront living." That was the moment my amusement disappeared. I returned home and unlocked the fireproof cabinet where I kept every important family document. Inside was the original deed, complete with the county seal, legal descriptions, survey references, and every transfer of ownership dating back decades. The boundaries were unmistakable. The lake belonged entirely to me. No easements. No shared ownership. No HOA rights. Yet someone was acting with remarkable confidence, and confidence like that usually comes from paperwork. Rather than confronting Linda or arguing with contractors, I called the county recorder's office and requested every public record connected to my property. If someone believed they had authority over my land, I wanted to know exactly what document gave them that confidence. Before the clerk could finish gathering the files, my phone buzzed with a notification from the county planning department confirming that an official vehicle had been dispatched to inspect the property that same afternoon, and suddenly I realized this was far bigger than one outrageous letter from an HOA president. The county vehicle arrived less than an hour later, but instead of bringing answers, it created even more questions. 2 planning officials stepped out carrying rolled maps and digital tablets. They were polite, professional, and completely convinced they were inspecting community property rather than privately owned land. I introduced myself, showed my identification, and asked under what authority they had entered my property. One official calmly explained that the inspection was related to infrastructure improvements connected to the neighboring residential development. When I asked why my lake appeared in those plans, he unrolled a large planning map across the hood of his truck. My stomach tightened. The map clearly shaded the entire 600 acres inside the HOA development boundary. I looked back at my original deed sitting inside my truck and then back at the county map. Both documents looked official, yet they completely contradicted each other. I thanked the officials for their time instead of arguing because I had already learned something important. This was no longer just an overconfident HOA president making empty threats. Somehow, government planning documents were now supporting the same claim. As soon as they left, I drove directly to the county recorder's office. The clerk searched every ownership record connected to my property and printed the complete chain of title. Every transfer matched my family's history perfectly. There had never been a sale, never a subdivision, never an easement granting the HOA any ownership interest. The recorder looked genuinely confused when I showed her a photograph of the planning map. She quietly admitted that planning maps were used for development purposes but did not legally transfer ownership. That single sentence changed the way I viewed the entire situation. Someone was relying on a planning document to create the appearance of ownership, hoping nobody would question the legal difference. I immediately hired a respected title company to conduct an independent examination and contacted a licensed surveyor to verify every property monument surrounding the lake. Neither of them had worked together before, which was exactly what I wanted. Independent opinions carried far more weight than coordinated ones. Before sunset, the surveyor called with his first update. Every visible boundary marker he had inspected matched the legal description in my deed. Nothing on the ground suggested the property had ever changed hands. An hour later, the title examiner delivered another surprise. The chain of title remained completely intact, but during a routine database search she discovered a recently recorded planning amendment referencing the surrounding development. It did not transfer ownership, yet it created enough confusion that anyone reading only planning records could mistakenly believe the lake belonged inside the HOA. That amendment became the newest mystery because nobody could explain who requested it, or why it appeared years after my family had secured clear ownership. As the second day of the 72-hour deadline approached, my phone rang from an unfamiliar number. The caller introduced himself as a retired county surveyor, and quietly said there was something about the original boundary records that I needed to see before anyone else found them. By sunrise on the second day, I was already driving toward a small coffee shop 30 miles away to meet the retired county surveyor who had called me the night before. He refused to discuss anything over the phone and insisted that someone might already be monitoring public record requests connected to the lake. His name was Harold Bennett, and after nearly 40 years working for the county, he had retired with a reputation for documenting everything. He placed a weathered leather folder on the table and slid it toward me without saying a word. Inside were copies of original boundary surveys dating back more than 5 decades. Every map matched my deed exactly. The property lines had never changed. The lake had never been part of any subdivision. Harold quietly explained that he had reviewed hundreds of developments during his career and had immediately recognized my property when he saw recent planning documents. He told me something that completely changed my understanding of the situation. Planning departments could draw proposed development boundaries for infrastructure coordination, but those maps could never change legal ownership. Only properly recorded legal instruments could do that. Then he pointed to a document I had never seen before. It was the planning amendment discovered by the title company, and attached to it was a supporting resolution bearing what appeared to be an official authorization. At first glance it looked legitimate, but Harold immediately noticed something unusual. The signature belonged to a county official who had retired nearly 3 years before the amendment had supposedly been approved. Either the date was wrong or someone had attached an outdated authorization to give the document credibility. I immediately photographed every page and drove straight to my attorney's office. After reviewing the folder, she became unusually quiet before finally saying exactly what I had hoped and feared at the same time. If that authorization could not be verified, the entire foundation supporting the HOA's claim could collapse. She immediately filed requests for certified copies of every document connected to the amendment, and contacted the county legal department for verification. Before lunch she received another unexpected response. The county agreed to schedule an emergency hearing because of the conflicting public records and the approaching deadline imposed by the HOA. The hearing would take place the following morning, only hours before Linda planned to assume control of the lake. Suddenly the countdown was no longer measured in days but in hours. As my attorney finalized evidence, another call came from an unfamiliar number. This time the voice belonged to a woman who introduced herself as a former administrative assistant for the HOA. She said she had watched recent events unfold in silence for too long and was finally ready to tell the truth. She claimed she still possessed archived meeting records and internal emails proving that the HOA leadership had known from the very beginning that the lake had never belonged to the association, and she was willing to bring everything to the courthouse before the hearing began. The woman arrived at my attorney's office carrying nothing more than a faded storage box, yet she looked as though she had been protecting it for years. Her name was Susan Walker, and she had worked as the administrative assistant for the HOA during the early years of the neighboring development. She immediately explained why she had remained silent for so long. She believed the dispute would eventually disappear because the lake had never legally belonged to the association, but once she saw construction crews placing signs around my shoreline, she realized the situation had gone far beyond an internal misunderstanding. One folder after another revealed board meeting minutes, draft development proposals, handwritten notes, and printed email conversations. None of them transferred ownership, but together they painted a picture that was impossible to ignore. Years earlier, the HOA board had discussed purchasing access rights to my family's lake because they believed waterfront amenities would dramatically increase home values. The proposal failed after their own attorney concluded that my family owned every inch of the property, and that acquiring it would require my voluntary agreement. Instead of abandoning the idea completely, later leadership quietly shifted their strategy toward presenting the lake as though it already belonged within the development. My attorney carefully organized every document, while I continued reading. Then we discovered an internal email sent directly to Linda Mercer shortly after she became HOA president. The message warned her that every recorded deed confirmed private ownership and specifically advised that planning documents could never replace legal title. Even more surprising, Linda had replied to that warning with a brief message acknowledging she understood the legal distinction. That single exchange changed everything. Until that moment, I had considered the possibility that she had simply misunderstood complex property records. Now it appeared she had been informed of the truth long before sending me the 72-hour demand. My attorney immediately added the email to the evidence for the emergency hearing. Just as we believed the strongest discovery had already been made, Susan opened the final folder inside the storage box. It contained copies of correspondence between the HOA and county planning staff discussing revisions to development maps. One attachment included the mysterious planning amendment that had caused so much confusion, but something immediately caught my attorney's attention. The approval page attached to the amendment did not match the formatting used by the county during that year. The document number followed an outdated numbering system that had already been replaced before the amendment supposedly entered the public record. That inconsistency suggested the supporting paperwork might have been assembled from older documents instead of being created through normal procedures. We immediately contacted the county legal department and requested certified originals before the hearing. Late that afternoon, the court clerk confirmed that every party would appear before the judge the following morning. As I prepared for the most important hearing of my life, my attorney received one final message from the county archives. The certified file had just been located, and according to the archivist, one page inside the original record was completely different from the version that had been circulating for years. The certified archive file arrived less than 3 hours before the emergency hearing, and my attorney opened the sealed envelope with the same care someone would use handling priceless evidence. The first several pages matched everything we had already collected, but then we reached the page the archivist had mentioned. It was not a dramatic confession or an obvious mistake. It was something far more powerful. The original approval sheet attached to the planning amendment contained a clear notation stating that the document existed solely for development planning purposes and did not alter ownership, title, easements, or private property rights. That single sentence had been completely absent from every copy that had been circulating between the HOA and developers. Someone had not changed the planning amendment itself. Instead, they had removed the page that explained its legal limitation. Suddenly, every confusing piece of the puzzle began fitting together. The planning maps were never intended to transfer ownership, but once that explanatory page disappeared, the remaining documents created the illusion that the lake had become part of the community. My attorney immediately requested a certified affidavit from the county archivist confirming that the page had always existed in the official file. While she prepared the emergency filing, I drove back to the lake one final time before the hearing. The shoreline looked almost unrecognizable. Contractors had stacked construction materials near the entrance, promotional banners advertised future waterfront amenities, and potential homebuyers were touring the neighboring development, while pointing toward the water. None of them knew they were looking at privately owned property. I did not interrupt them because my argument would not be made in the parking lot. It would be made with certified records inside a courtroom. As I returned to my truck, I noticed Linda Mercer speaking confidently with several development representatives beside a display showing the future resort layout. She smiled as if everything had already been decided. She never noticed me quietly taking photographs of the display, which included my lake highlighted as the centerpiece of the community. Those images would become another piece of evidence demonstrating that the HOA was presenting private property as its own before any legal determination had been made. Back at the courthouse, my attorney received one final report from the independent title company. After reviewing every recorded instrument, they concluded there had never been a lawful transfer of ownership, no recorded easement granting public access, and no document authorizing the HOA to manage or control the lake. Their opinion was clear, direct, and supported by decades of recorded history. With only hours remaining before the 72-hour deadline expired, every major question seemed to have an answer except one. If the official county archive still contained the complete record, who had been distributing incomplete copies for years? That mystery became even more urgent when the court clerk informed us that the county legal department had requested permission to address the judge before either side presented its case, suggesting they had uncovered something neither the HOA nor my legal team expected to hear. The courtroom felt surprisingly quiet, but the silence carried more weight than any raised voice ever could. As I took my seat beside my attorney, I reminded myself that every decision made over the past 3 days had been based on evidence instead of emotion, and now the evidence would finally speak for itself. Before either side presented opening statements, the judge acknowledged the county legal department's request to address the court. That unexpected decision immediately caught everyone's attention, including Linda Mercer, who confidently sat surrounded by representatives from the HOA and the development company. The county attorney began by explaining that an overnight review of the certified archive had revealed an important discrepancy between the official record maintained by the county and several unofficial copies that had been circulated during the planning process. He then displayed both versions side by side. Even from my seat, the difference was obvious. The certified original included the page stating that the planning amendment had absolutely no effect on ownership, title, easements, or private property rights. The circulated version omitted that page entirely. The county attorney carefully clarified that planning maps existed only to coordinate future development and public infrastructure. They could never transfer legal ownership of private land. That statement alone completely changed the direction of the hearing. Linda's attorney immediately shifted strategies and argued that the HOA had relied upon the incomplete documents in good faith. My attorney calmly stood and introduced the archived email Susan Walker had provided. The judge carefully read the exchange showing that Linda had been explicitly warned years earlier that my family's deed remained controlling and that planning records could never replace legal title. Linda had acknowledged receiving that warning in writing. Suddenly, the argument that this had been an innocent misunderstanding became much more difficult to accept. My attorney then introduced the certified chain of title, the independent title company's findings, the survey confirming every original boundary monument remained untouched, and the photographs I had taken showing the HOA marketing my private lake as a community amenity before any court had ruled on ownership. Each document supported the next, creating one consistent timeline that stretched back decades. The judge spent several minutes reviewing the evidence without interruption before asking one final question of the county attorney. Had any lawful instrument ever transferred ownership of the lake from my family to the HOA? The answer came without hesitation. No. Not once in the recorded history of the property. For the first time since receiving the 72-hour demand, I felt the pressure begin to lift from my shoulders. Yet before the judge announced a ruling, he requested a brief recess so the county could verify one remaining issue involving the source of the incomplete planning documents. As everyone slowly stood to leave the courtroom, the county attorney quietly approached my attorney and handed her a newly delivered investigative memorandum. She read the first page, looked directly at me, and whispered that the document identified exactly where the altered copies had originated, and the answer reached much farther than the HOA board alone. When the courtroom reconvened, everyone expected the judge to announce a decision, but instead the county attorney requested permission to submit one final piece of evidence that had arrived during the recess. My attorney handed me the investigative memorandum, and I quickly understood why she had reacted so strongly. The County Archives Division had traced every official request for copies of the planning amendment over the past several years. The certified original had never been altered inside the county records. The missing page disappeared only after copies were requested and distributed outside the archives. Even more surprising, every incomplete version originated from the same private planning consulting firm hired by the neighboring development long before Linda Mercer became HOA president. That discovery immediately changed the story. The county attorney carefully explained that there was no evidence anyone inside the recorder's office had modified public records. Instead, incomplete planning packets had been repeatedly circulated during meetings involving the developer, consultants, and HOA leadership. The judge then turned toward Linda's attorney and asked whether the HOA had ever compared those planning packets with certified county records before demanding ownership of private property. The courtroom remained silent for several long seconds before the attorney admitted they had relied on the documents provided during development planning. My attorney stood and calmly introduced the archived email showing Linda had already been warned years earlier that certified deeds controlled ownership regardless of planning maps. That warning meant she had every opportunity to verify the records before sending me the 72-hour demand. The judge slowly reviewed the email once more before placing it beside the certified archive file and my family's chain of title. Then another unexpected witness was called by the county attorney. It was the retired county surveyor, Harold Bennett. He explained how boundary monuments surrounding my lake had remained unchanged for decades and testified that every licensed survey conducted during his career recognized the property as privately owned. He also confirmed that planning boundaries often extended across private land for engineering purposes, but never changed legal ownership. His testimony connected every independent piece of evidence into one consistent timeline. The survey matched the deed. The deed matched the title records. The title matched the county archives. The only documents creating confusion were unofficial planning packets missing a critical explanatory page. As the judge organized the exhibits, I noticed Linda no longer looked confident. She quietly reviewed papers with her attorney while several development representatives avoided eye contact altogether. The courtroom atmosphere had completely shifted. What had begun as a dispute over a lake had become a lesson about the difference between planning documents and property rights. Just before the judge prepared to announce his findings, the county attorney requested that the investigative memorandum also be forwarded to county administrators for an independent review of the planning consultant's document distribution practices. The judge approved that request without hesitation. Then he looked directly at both legal teams and announced that the court had reached its conclusion regarding ownership. But before reading the final order into the record, he wanted one last confirmation from the county recorder herself concerning the legal status of my original deed. The county recorder stood, raised her right hand to affirm her testimony, and answered the judge's final question without hesitation. She confirmed that my original deed remained a controlling legal document governing ownership of the entire 600 acres and that no recorded instrument had ever transferred any portion of the lake to the HOA or the neighboring development. She also confirmed that every certified copy issued by her office had always included the explanatory page attached to the planning amendment. That testimony removed the last remaining uncertainty from the case. The judge carefully reviewed the evidence one final time before reading his findings into the record. He explained that planning documents served important purposes for development coordination but could never replace recorded property rights. He further noted that relying on incomplete planning materials without verifying certified ownership records had created unnecessary confusion and had resulted in an unlawful demand against the private property owner. The court declared that my family's ownership of the lake remained exclusive and uninterrupted. The emergency order immediately prohibited the HOA from representing the lake as community property, advertising access to it, or exercising any authority over it. Every sign installed around the shoreline would have to be removed, and every promotional brochure identifying the lake as an HOA amenity would require correction. As those words echoed through the courtroom, I felt 3 exhausting days of uncertainty finally begin to disappear. Linda Mercer remained silent, while her attorney quietly explained the court's order. Across the room, several representatives from the development company appeared more concerned about revising future marketing plans than continuing the dispute. My attorney smiled for the first time since this entire ordeal had begun, and reminded me that calm preparation had accomplished far more than anger ever could have. After the hearing ended, county officials met with both legal teams to coordinate immediate compliance with the order. Contractors were instructed to suspend all work connected to the lake until every promotional reference had been corrected. Before leaving the courthouse, I drove back to the property with my attorney. By late afternoon, workers had already begun removing the polished entrance signs that only 2 days earlier had confidently announced future community access. Watching those signs disappear was satisfying, but what mattered most was not the removal itself. It was the public recognition that ownership had never actually changed. The truth had simply been hidden behind incomplete paperwork and assumptions that nobody would verify the original records. As the sun settled over the water, my phone rang one more time. It was Susan Walker calling to thank me for pursuing the truth instead of accepting the demand or responding with frustration. She then shared one final piece of information that none of us had expected. During the HOA's emergency board meeting held immediately after the hearing, several board members had questioned how the demand letter had ever been approved despite years of documented legal warnings. An internal review had already begun, and according to Susan, the answers hidden inside those board records could reveal decisions reaching back much farther than anyone had imagined. The following week, I returned to the lake before sunrise, not because I feared someone would try to take it again, but because I wanted to experience something that had almost been lost forever. The water was perfectly still, the morning mist drifted slowly across the shoreline, and for the first time in days there were no construction crews, no promotional banners, and no unauthorized survey stakes interrupting the quiet landscape my family had protected for generations. The emergency order had been fully carried out. Every sign claiming the lake belonged to the HOA had been removed, marketing materials had been corrected, and county officials had formally notified every party involved that ownership had never changed. A few days later, I received copies of additional public meeting records showing that the HOA board had accepted Linda Mercer's resignation after conducting its internal review. The board also voted to adopt a new policy requiring independent verification of certified property records before approving any future claims involving private land. The neighboring developer released updated advertisements removing every reference to community ownership of the lake, and prospective buyers were informed that the waterfront remained entirely private. What surprised me most was that several homeowners from the surrounding neighborhood reached out to apologize. They admitted they had believed the promotional materials because they assumed official-looking maps must always reflect legal ownership. None of them had realized there was an important difference between planning documents and recorded deeds. I welcomed every respectful conversation because this had never been about winning an argument against neighbors. It had always been about protecting the truth contained inside public records. Looking back, I realized the greatest lesson had nothing to do with 600 acres of water. It was about patience. If I had responded with anger, confronted workers, or ignored proper legal procedures, I might have created confusion instead of clarity. Instead, every step was supported by evidence. The original deed established ownership. The survey confirmed the boundaries. The title examination confirmed the chain of ownership. The archived emails revealed prior knowledge. The certified county file restored the missing explanation. Each piece alone answered only part of the mystery, but together they revealed the complete story. Months later, I received a letter from the county informing me that new administrative procedures had been implemented to ensure certified planning documents would always include explanatory notices distinguishing development planning from legal ownership. Harold Bennett called simply to tell me he was glad decades of careful surveying had helped preserve the truth. Susan Walker thanked me again because she believed the archived records had finally been used for the purpose they were meant to serve. As I stood on the dock watching the sunlight spread across the lake, I understood that justice had not come from dramatic speeches or personal revenge. It came from ordinary people choosing facts over assumptions and records over appearances. The lake had never really been in danger of belonging to someone else. What had almost been lost was confidence in the system designed to protect ownership. Fortunately, one forgotten deed, one complete archive, and a commitment to follow the law all the way to the end were enough to make sure the truth remained exactly where it had always belonged.